Last month, Justin Baldoni and the Wayfarer parties filed a motion for judgment on the pleadings, which is a little bit different than their motion for summary judgment. In her opposition to that motion, Blake Lively made an extremely bizarre claim, trying to tie misconduct to California. As we know, the majority of filming and all of that took place in New Jersey, and this stuff at the premiere and all that happened in New York. But in trying to tie alleged misconduct to California, Blake Lively made some interesting choices. The most interesting and probably controversial being this statement about being birthed into the role. So here's what Blake Lively said. She said, other actions in California set the tone for harassment. Shortly after Miss Lively accepted the role of Lily Bloom, Mr. Heath remarked that Miss Lively would be birthed into the role, a statement that sexualized her and invoked female reproductive imagery to describe her professional contributions. This objectification, made from California, where Mr. Heath resided, signaled that Miss Lively's value was tied to her gender rather than her talent. And honestly, that said a lot less to me about Miss Lively's talent so much as it did about her own self-image. If you're that sensitive about something like that, it's because you already think that about yourself, because what that man said was nothing of the sort. And that's assuming she's even relaying that message correctly. But this is the second time, and even the second time, with Jamey Heath being the target of her weird obsession with this kind of thing. This is the second time that she's taken something involving childbirth and babies and tried to make it something sexual. It's creepy. It's weird. I don't know why you would want to put that in writing, but I guess when you control the tabloid headlines and the legacy media, you can get away with a lot more shit. Anyways, the Wayfarer parties had a chance to respond to that opposition, and I'm going to go over it. We're not going to do it word for word, and it's much shorter than the motion for summary judgment, but I will run through the highlights here. And they do address this statement about the word birthed into a role as it's a figure of speech. It's not literally talking about Blake Lively crawling out of someone's hole or anything. Like, I can't believe those words just came out of my mouth. But then again, I can't believe what I just read, even though I read it a week ago, and now I still can't believe it. But they do address that statement in this response. So let's go ahead and take a look. Lively's opposition hinges largely on extrinsic evidence, including all arguments and evidence submitted in support of her opposition to defendant's summary judgment motion, an implicit admission that, as pleaded, her claims are deficient. Lively, however, provides no authority that might permit the wholesale incorporation of facts and argument that purportedly would have supported her claims had they only been pleaded. This is a pleading motion directed to deficiencies in the complaint. By relying on extrinsic evidence first submitted in connection with a summary judgment motion, Lively concedes that her complaint, standing alone, is insufficient to plead her claims. Succinctly put, deficiencies in a complaint cannot be retroactively cured by evidence submitted in a summary judgment opposition or merely preferred in opposition to a Rule 12c motion. So my kind of plain language layperson understanding of this is that they're saying Blake Lively's opposition to this motion relies on evidence or arguments that aren't actually in the complaint itself. So they say that she's effectively admitting that her, arguments in her complaint are insufficient. They say that she's not really showing any sufficient legal authority that would, allow the court to bring in these facts and arguments after the fact. So even if these things, might have helped her complaint if she had brought these things into it in the first place, she didn't, and they're saying that the court should now not, bring these things in retroactively. They're trying to say that Blake is ignoring these limitations of the court where they're supposed to take the complaint, the pleadings on their face. And we're not really thinking about the stuff that's come out in discovery and all that. We're just thinking about the pleadings themselves. I might have just tossed up a little bit of a word salad, but I'm doing my best here. When deciding a motion on the pleadings, the court must confine its consideration to the pleadings and their attachments to documents incorporated in the complaint by reference and to matters of which judicial notice may be taken. Implicitly conceding that as pleaded, her claims cannot withstand a motion to dismiss, plaintiff offers several options for the court to consider extrinsic facts, including 1, the wholesale incorporation of arguments and evidence submitted in connection with her summary judgment opposition, 2, conversion of defendant's motion for judgment on the pleadings to a motion for summary judgment, and or 3, an amendment to conform the complaint to proof. The court should decline plaintiff's invitation to depart from the rules applicable to motions to dismiss. Plaintiff first fails to cite authority for the notion that all arguments and facts set forth in her summary judgment opposition can be incorporated into her opposition to a Rule 12c motion to dismiss. To the contrary, a party may not incorporate by reference an argument in a summary judgment motion into a motion for judgment on the pleadings. Plaintiff punts to Rule 15b2, which provides that when an issue not raised by the pleadings is tried by the parties' express or implied consent, it must be treated in all respects as if raised in the pleadings. The rule further provides that a party may move at any time, even after judgment, to amend the pleadings to conform them to the evidence and to raise an unpleaded issue. Rule 15b amendments to conform to proof have been permitted to add new claims or legal theories in the context of a summary judgment motion where a fact or evidence has been placed at issue and thus raised with the party's consent. So this Rule 15b2, I guess, is saying that if some issue wasn't originally brought up in the pleadings, but it was later implicitly or explicitly litigated, then it can be treated like it was properly pleaded in the complaint at the start, and the party can formally ask for the pleadings to be amended. But this rule only applies when the parties have already litigated the issue and they've consented to do that. The Wayfarer parties, to my understanding, are trying to say that the rule does not apply here because the issue she's trying to raise, they were not tried with consent. Here they say defendants did not raise Lively's new evidence or indeed any evidence in its Rule 12c motion, which focuses solely on the legal deficiencies. And of course, the facts have not been tried at trial or at an evidentiary hearing, so defendants have not consented to try the new facts or evidence proffered by Lively. Finally, defendants did not raise the issue of extraterritoriality in their summary judgment motion and therefore did not try the issue by consent. Even assuming consent to the admission of extrinsic evidence on a motion to dismiss can be created by presenting evidence in support of a summary judgment motion. Defendants do not dispute that Rule 15b allows a party to move at any time, even after the judgment, to amend the pleadings to conform to the evidence, but Blake has not moved to amend her pleadings, even though the defendant's motion was filed on September 26th, giving her ample time to seek a proper amendment, affording defendants the opportunity to oppose an amendment to add new facts. Was this really filed in September? Shit. I thought it was last month. No, I guess they just filed the motion for summary judgment last month. No, that's right. They did bring this up initially a while ago. And she still hasn't asked to amend. Plaintiffs suggest that because defendants presented evidence relating to an adverse employment action in their summary judgment motion, the court should convert the motion for judgment on the pleadings. Conversion, however, is appropriate when a moving party bases its motion to dismiss on extrinsic evidence. Defendants have not cited any extrinsic evidence in support of its motion for judgment on the pleadings, and plaintiff does not cite any decision in which a court has converted a motion to dismiss to a summary judgment motion because plaintiff opposed with extrinsic evidence. Any such rule would obliterate the distinction between motions to dismiss for a failure to state a claim and summary judgment. So Wayfarer is saying that's not how the rules for conversion work. They didn't rely on any outside evidence when they were making their motion for judgment on the pleadings. And if Blake had things her way, the way that she describes it, it would basically eliminate all difference between the motion for judgment on the pleadings, which only looks at the complaint, versus a motion for summary judgment, which considers the evidence. Plaintiff concedes that the complaint fails to allege an adverse employment action under FEHA or Title VII. She doesn't even bother to address her failure to plead an adverse employment action as required for retaliation. Plaintiff only glancingly refers to an adverse employment action in her introduction, stating in the most conclusory fashion that she more than adequately pled an adverse employment action and causal links. Failure to oppose an issue raised in a motion to dismiss effectively concedes the issue. So she didn't really say anything of substance there. She just said, as a conclusion, well, I more than adequately did that. Plaintiff merely directs the court to the arguments and evidence submitted in her summary judgment opposition. As explained above, a party cannot effectively oppose a legal argument framed in defendant's motion to dismiss by simply incorporating by reference an argument asserted in her opposition to defendant's summary judgment motion, and doing so cannot retroactively cure a failure to state a claim in the first place. In fact, the only plausible explanation for this critical omission is that plaintiff seeks to evade the court's 25-page limit for her opposition. Incorporation by reference is not a proper device to avoid the page limits. Since plaintiff concedes that she failed to plead an adverse employment action, her retaliation claims under FEHA and Title VII should be dismissed. In a particularly muddled argument, plaintiff argues that a choice of law provision in plaintiff's unexecuted loan-out agreement, so the ALA, abrogates California's firmly established presumption against the extraterritorial application of FEHA. God, I'm just going to start saying ET because I keep wanting to say extraterrestrial. So they're saying that she's implicitly acknowledging that that argument isn't so great because she's falling back on facts that, again, are extrinsic to the complaint to establish a nexus between California and the elements of her FIHA discrimination and retaliation claims. These arguments not only fly in the face of firmly established California law, but contradict plaintiff's own pleading. To salvage her claims under FIHA, plaintiff engaged in a tortured choice of law analysis to argue that California's presumption against extraterritoriality does not apply even though Lively is not a California resident, and her own pleading establishes that the allegedly offending conduct occurred outside California in New York and on the New Jersey set of It Ends With Us. Lively suggests that a choice of law provision in her unexecuted ALA somehow supplants the rule governing extraterritoriality and that FIHA does not include a geographical limitation. The parties could not contract around the extraterritoriality constraints of California statutes even if they wanted to. Contrary to Lively's allegations, FIHA contains clear geographical limitations. In short, the ALA's choice of law provision does not abrogate the well-established principle that the presumption against extraterritoriality applies to FIHA. To overcome the presumption, Lively must plead a specific factual nexus between the defendant's California activities and the majority of allegedly discriminatory conduct. Lively admittedly did not plead the required nexus and instead urges the court to consider new facts that purportedly create the necessary link, and the new facts proffered by Lively are insufficient to establish the requisite factual nexus. Lively points to a pre-production statement by Jamey Heath, presumably in California, hoping for a successful birthing of the film project. So it sounds like he didn't even specifically say to Blake Lively, you're being birthed into the role. He was saying something about a successful birthing of the film project, creation, a beginning. We all know that that's a figure of speech. Even if you think it's weird, it's still a figure of speech. It strains credulity to argue that using the term birthing as a substitute for creating was sexual or harassing in nature. So it's true that it's hard to believe that she actually thinks that using the term birthed or birthing there is sexual. But then again, maybe she just really is that gross because this isn't the first time she's made something about birth sexual. In my opinion, it harms her credibility that she would even make this argument, but that's just to the layperson and the public reader. I don't know how, people who actually practice law felt when reading that statement, but I can only tell you, how it felt as a bystander, I guess, an onlooker, whatever you want to call me. I don't know. Onlooker sounds creepy. Let's not do that. Okay, moving on. More importantly, there is no allegation or evidence that Heath or any Wayfarer party knew or had reason to anticipate discriminatory conduct. In this vein, Lively notes pre-production communications relating an HR department and Wayfarer's decision not to have a full-blown HR department for the film. According to Lively, such decisions, purportedly made in California, set the tone for harassment. Whatever that means, a decision on the scope of HR services without any link to a motive to promote harassment or somehow avoid future liability for harassment is not sufficient to plead a causal link between California and discriminatory conduct which allegedly occurred on the film's set in the spring of 2023. Lively also points to complaints by Lively to Sony about conduct on the set. Sony was not Lively's employer. Sony is not affiliated with Wayfarer, and as Sony told Lively, was not a proper party to receive her complaints. Sony referred Lively to the Wayfarer principals in New York. Even assuming the court were to consider these extrinsic facts, they are insufficient to plead a nexus between the allegedly wrongful conduct on the film's set and California. As for Lively's retaliation claim, Lively contends it was created and launched by crisis manager Melissa Nathan, public relations representative Jen Abel, and Jad Wallace. While Nathan and Abel may have been in California, they are not Wayfarer employees, were not involved in the allegedly wrongful conduct, and cannot be liable for retaliation wherever it occurred. Lively fails to show that her defamation claims are adequately pleaded. Lively again relies primarily on extrinsic evidence presented in her summary judgment opposition to refute defendants' arguments on the deficiency of her defamation claims. First, relying solely on citations in her summary judgment opposition, Lively contends that defendants' opinion defense is meritless. However, the only defamatory statements identified by Lively are Mr. Friedman's statements to the press on his opinion on the merits of Lively's claims and conduct in the litigation. Lively argues that New York and California's litigation privileges do not apply to statements to the press. Mr. Friedman's statements, in contrast, were made after Lively filed her complaint in December 2024 and expressed his opinion on the merits of her claims. Lively next argues that New York's fair report privilege does not apply because the defamatory statements constitute litigating in the press and do not reflect reports of any judicial proceeding. And the fact that this lady would complain about someone else litigating in the press is fucking amazing to me. Lively again turns to her opposition to defendant's summary judgment motion, pointing to statements which she alleges were not made to report on judicial proceedings. However, the statements by counsel, to the extent they can even be construed as defamatory, which they are not, merely repeat defendant's assertions made in court and fall within the scope of protected speech under Section 74. Lively's joint employer argument is misplaced. She devotes 2 pages to an argument that defendants did not make, namely that Wayfarer should not be dismissed because, although Wayfarer was a joint employer with It Ends With Us movie, liable under FEHA and Title VII. Okay, the sentence structure there is a little weird. So she says Wayfarer shouldn't be dismissed because they were a joint employer with It Ends With Us movie, so Wayfarer should also be liable. Okay. In a footnote, defendants merely note that Lively blurs the lines between Wayfarer and It Ends With Us movie, Lively's employer. Even if defendants made this mythical argument, Lively's joint employer theory was not adequately pled, as there are no allegations that Wayfarer paid Lively's salary, hired her, or had any control over her daily employment activities. So there are a lot of documents in the oppositions and the motions for summary judgment on the pleadings that they're going to have to unseal that stuff, but it's going to be a while. I think the judge set a specific deadline for requests to continue sealing things. Was it like the 19th? I don't know. It might be Friday. I don't know. I could be totally wrong on that, so don't quote me on it, but I'll figure it out. So as soon as that stuff comes out, we'll be able to go over it. As we know, Blake completely sealed her declaration, Don Saladino, the trainer's declaration, any of her deposition testimony transcript, and just a whole host of things. So basically, we don't really get to see any of the statements she's making, and I think there's a purpose for that. Whether or not those things will continue to be sealed, I don't know. But I'll keep an eye out. All right, that's all I got for now, guys. Thanks for watching. I will see you guys later.